Thank you, everyone, for being here for another legal talk series at Duquesne Kline Law Library. And it is my pleasure to introduce today Professor Maryann Herman.
Thanks, Donna.
Welcome, Maryann. After having successfully fulfilled her role as Director of Academic Excellence, Professor Maryann Herman joins the tenure-track faculty at Duquesne Kline as an assistant professor of law. She teaches property law. Having taught legal reasoning and law school skills courses, she strives to integrate skills concepts into a doctrinal classroom, improving the learning of all her students. Prior to joining Duquesne Kline Law, Professor Herman served as the Director of Academic Success and Bar Preparation, studies at the Appalachian School of Law, and practiced at the Chicago Legal Clinic, an organization serving low-income clients. A Detroit native, Professor Herman embodies what I consider the best of the American ethos, an unshaken sense of fairness and hard work. The reasons, perhaps, why she's such a remarkable colleague. Thank you, Maryann. She received her Juris Doctor degree from Wayne State University in Detroit. Now we are going to start with our 10 questions. The first one, after this introduction, how would you like to introduce yourself?
Wow, thanks, Donna. I certainly appreciate that introduction, and I don't think I can do myself that sort of justice. But as you had said, I'm an assistant professor here at Duquesne Kline School of Law, and I consider myself a teacher scholar. That is, I am here because I want to help students learn. I want to teach students, and I think my scholarship is there to support that.
Thank you so much. And I think you add a sense of modesty that is so rare among law faculty. The second question, what inspires you to write?
What inspires me to write? Well, there's a couple things, right? First off, my teaching. I really feel that in order to teach, to convey these concepts, that it's really helpful to look at some of them in depth. But what inspires me to write those particular things is just people, right? I write on property concepts and how we use property, and it's about people, where they live, how we live in society. And that's what inspires me to write, just things that happen every day, Donna.
This is wonderful because property, as we both know, is regarded as one of the fundamental freedoms here in the US. Yeah. But what is remarkable in my eyes about your current and most recent scholarship is the fact that you pay attention to a fiction about property. Right now, we cannot have absolute property. We don't live one person in one forest.
Right.
There are limitations. And not only are you trying to express property in its reality and its complexity, but you are taking on the purpose of ownership, especially from a public interest perspective. And I commend you for that.
Well, thank you. Thank you. Certainly something I strive to do, so thank you.
Is it something related to your Detroit background, you think?
Yeah, I do, right? I write primarily and focus primarily on urban problems, urban land use, urban issues, and having gone to school and lived in Detroit, and now here in Pittsburgh, which has similar issues. There's all sorts of land use issues and problems, and how we live together as a society, and how industry plays into that, and what we do once that industry is no longer viable.
Thank you. So we're moving forward with who are your favorite legal writers?
That's a good question, Lana. So I think I have two kind of camps of legal writers that I like. First, of course, property writers, as I study and write in property, and those writers who really kind of look at our conception of property here in the United States. And why we look at property the way we do. So, of course, Margaret Redden, who writes about the personhood theory of property, and also Lee Fennell, who has written about my favorite article, The Fee Simple Absolute, which she calls the Fee Simple Absolute. And then there are some writers who also write on more current, perhaps practical issues. And one of my favorites that just came out is Michael Pollock, who comes out of Cardozo, writes about sidewalk law. And that is really interesting to me to think of, like, who owns the sidewalk and who should own the sidewalk and why, and who maintains the sidewalk. And it really makes you think about and consider the primacy of individual automobiles for transportation here, and what that does to equity and just quality of life. So those are some property writers I really like. There's just a lot of great writers out there who consider how we use fundamental property principles now, right? And I also like writers that write about legal education, and specifically pedagogy and teaching. Of course, my favorite, the person I've learned everything from, Michael Hunter Schwartz, who writes all about teaching. Also, Paula Manning, who's now at Detroit, is wonderful as well.
I have to admit, total ignorance. Would you please pick one of your favorite writers and tell us a little bit more about what exactly in their work, inspired you? Because I think our listeners
more read Margaret Radin, who writes about the personhood theory of property and how property really helps people, ownership of property specifically helps people develop as people, right? We need some control over externalities in order to really develop. I like her writing, although I don't think it explains everything by any means, but it does kind of broach the subject of why we find individual property so important here, not just in the United States, right, but throughout society, why individual ownership is so important, especially when we're talking about real property and about homes, is that, like, these things are central to our development. And I think the question is, does it need to be? Why is it? But she certainly lays out the argument that it is.
Thank you. I was unaware of her scholarship, so I really appreciate.
Yeah, she's certainly a pioneer, I guess, in the area of property. I also like a lot of writers in legal pedagogy. As you know, we go to school to become lawyers, just like the rest of our colleagues, not teachers. So when we begin teaching, and we throughout our careers, right, teaching, we want to learn how to be effective teachers. And there's a lot of good writing out there about it, about how to best convey and help students understand these concepts that can be difficult and esoteric, right? So my favorite is probably Michael Hunter Schwartz. And the reason I will always name him and like him so well is because when I started teaching, I didn't know what I was doing. And so I saw, once I read his work, it was just so eye-opening that there was a way, like a method to actually teach law, and not just stand up there and prattle on and call on people. And so he, has certainly, his work has been formative in my career teaching.
Will you give us a tidbit, an example that
yes.
made a change?
So as you know, and all lawyers know, and all law students know, the hardest part about any writing an exam, writing a paper, is the analysis. And oftentimes we just tell students, well, you apply the rule of the set of facts, right? But that doesn't really mean anything to a new law student. They think they're applying the rule of the set of facts, and they bring it to us and say, no, you got to apply it. And that's not incredibly helpful. So Michael Hunter Schwartz has a particular method to do that. And I believe he calls it fill. And you state the fact, state any inferences necessary to link that fact back to the rule, and then link it back to the rule. And I have I've changed it into full, as my students know, but we do the full analysis, and that comes from Michael Hunter Schwartz. And I certainly hope it give students a little paradigm on how to write a good thorough analysis.
I know how hard it is because I started what I consider an experiential course that I'm teaching on climate change.
Mhm.
And I know that the hardest from the perspective of the students is the analysis. How
Yeah.
do you write
Mhm.
an argument that is persuasive when
Mhm.
you start with just one legal research question
Right.
or an element?
Yeah, it's quite difficult.
It is.
So I think that it's helpful for students to be able to have some sort of paradigm to follow, that kind of gives a reminder of what should be in an analysis. And of course, as students become more practiced, it's second nature, right? To think about how you're going to analyze something and what you need to explain, but it's certainly not second nature to new law students.
Absolutely, and I can't wait to read in an article authored by Maryann Herman what full means.
Yeah, well, hopefully, hopefully that will happen, Donna.
I hope so. Moving along to question 4. What piece of your scholarship would you like to talk about today?
So I had a piece recently come out in the Pitt Law Review, just down the street from here, proposing a new easement used an easement for the community in certain instances of eminent domain. And in that piece, I proposed using an easement, the property interest of an easement, to give certain former landowners a right to say what's going to happen to this property that was taken from them and conveyed for public use to some private entity to ensure that it's really used for public use.
If I may say, when I first heard you explain this particular piece of scholarship, I loved it. I loved it because it's so rare to have a true scholar who understands both individual private property and the easement in favor of the public. That's why it's called public domain. And what happens when that is not followed through?
Yeah, and I think that that's an important point. Certainly this topic has been written on quite a bit and solved legally in certain many places, right? But I also would argue, probably a bit contentiously, that eminent domain is a tool that is needed, right, by our municipalities, and development and industry is also a tool that is required for our communities to thrive. The question is, how do we get those two things to work together to ensure that the industry, the development, is serving the community? Of course, it's never going to be the primary function, but how do we marry those things together so that the community, that society is benefited, especially if their land was taken for that purpose? I think that these public-private partnerships that it's here, right? We're stuck with that. And so to think about how we can use property concepts that already exist to help solve this, it's interesting.
It is, and somehow, in light of the current decisions by the Supreme Court, and if you don't mind mentioning your contribution to a recent CLE, a lineup of professors talking about recent Supreme Court decisions, I think this is so crucial because it seems, and I repeat myself, that you're among a minority of scholars who really understands that we need both private and public have to be married together in order for our democracy to continue the way we have it. And I think we all love it, especially immigrants like me. So would you mind please telling us a little bit about what you talked at the a recent lineup of professors talking about the Supreme Court decision.
Donna, and I think we're seeing our Supreme Court now holding paramount individual property rights. I talked about the case, Tyler versus Hennepin County. In that case, the county or the state, it was the state of Minnesota, has a statute in place that allows an entity, a municipality, to take and sell tax delinquent property, which is normal and
Yes.
fine, and there was no issue with that statute in itself. The problem with the statute is that it dispersed the proceeds of the sale to all sorts of city entities and county entities, and of course paying the tax debt, but it didn't allow for any of the proceeds that were left over to go to the former property owner. So in this case, the former property owner, Tyler, sued Hennepin County, and the court found that that was unconstitutional, that was an unconstitutional taking of property in that case. Well, you know, it's really hamstrings municipalities
Yes.
to do this, because in a lot of cases, these tax delinquent properties aren't sellable, right? They're not sellable. They're not going to get any profit. And so, those that do oftentimes will subsidize those that do not. They have to do something with these properties that tax isn't being paid on, or perhaps might be abandoned. So in this case, they can't do that anymore. And when we're talking about property rights and individual property rights versus the rights of society or the community in that property, we see in this case that the court is holding above the community rights, right? The rights of that one individual to have the proceeds. It's a problem, right? Because we don't live as individuals. We live in communities. We have governments, municipalities, counties in this case that care for these properties. And yeah, it's going to continue to be problematic in a few ways, this court's recognition or this court's willingness to see something as a taking.
I'm so grateful that you are so focused on this balance between community and private, and I'm going to annoy our audience, because I think it is disingenuous what's going on at the Supreme Court level. They receive these little stories, little tidbits that are so interesting if you were to read them, I don't know, in a Faulkner a novel. And of course, it sounds unfair if a particular person doesn't receive the proceeds from the sale, but there is more to that story. And as you said so persuasively, we live in a community and we have to take care of each other.
Yeah, and the problem is there was a lot more to that story, right? That really didn't get told. And the law is the law, and if that's the law of taking, that's the law of taking. But it really isn't, right? This is new. This is a new form of taking, and there's a lot more going on behind the scenes than was expressed in this very short Supreme Court opinion. That it just has a lot of emotion behind it.
The complexities of this case, I hope you're going to write about them
Yeah,
and have them
absolutely.
published
And
in the
Duquesne.
Duquesne Law Review.
Yeah, of course.
I look
I'm
forward
excited
to
for
reading
that.
that. Thank you. Moving along. Okay, our fifth question, you already mentioned some of the main ideas behind it. Would you like to add anything, or shall we move forward?
The one thing I would say about it is that I'm really interested in seeing or thinking about how we can use current property concepts or old property concepts, things that we study in first year property law, to solve specific or address. I don't want to use the word solve. That's a little strong. To address current specific problems. Because of this, it kind of really ties together my interest in land use and the way we live and teaching, right? So I found writing this piece just really useful in tying together a few concepts that we talk about in the first year, and also being able to express to my students why these things are so important.
Thank you. So the sixth question, what does it add to the existing body of literature in this field?
Yeah, so there's a lot of literature in this area for sure. But this actually just proposes a new easement. So it adds that interest, this durable property interest that would belong to the community, that would allow them to like block the usage that isn't in conformity with community aid.
I'm going to be like a little dog, that doesn't want to let that dog go away. Would you please explain to us with an example what exactly your solution, which I found remarkable, new, adds to the body of literature?
Yeah, so this solution was proposed in cases of takings, which, are not allowed in a lot of jurisdictions anymore, but takings by the government from one private entity and then conveyed to another private entity. Because the usage by that second private entity would provide some public benefit. So the example I use in this paper comes from my experience, right, in Detroit, and the case of the Poletown plant. So in the case of Poletown, land, a lot of land, houses, churches, hospitals were taken from by the government, by the city of Detroit, by eminent domain, and then conveyed to GM to expand a plant, the Poletown plant, which is still there and still functional today, based on the fact that it would provide a tax base and provide jobs to the people of the city of Detroit and also Hamtramck. So, this was a very, very, very contentious use of eminent domain for a lot of reasons. With the normal use of eminent domain, you're not conveying it to a private entity here to GM, you're keeping it for use by the government itself. So in this paper, I propose an easement held by community or community organizations in this case that could compel in court GM to use this factory in a way that does benefit the public, in a way that does provide jobs, in a way that does provide taxes to the community, to support the community. Poletown's been very beneficial to that community. I mean, it does provide jobs, it does provide a tax base. Of course, and all the things we propose in our legal scholarship, it certainly has limitations in that, like, it would have to be a feasible use. But yeah, so the idea is to take this existing property interest, the easement, and apply it in this novel situation.
I really applaud you for that, and I can't wait to see the follow-up piece. And something based in Pittsburgh.
Yeah.
So moving along, and I have to acknowledge the beautiful people in the audience. Thank you. How do you think the publication of this particular piece has affected your teaching and scholarship so far?
Well, it's affected immensely in that now I have a new job, right? So this was my job talk paper that allowed me to get my new tenure track job here at Duquesne. Thank you. I'm quite pleased to be here.
I am. I'm very, very happy and proud of you.
But I teach property. I've taught property. This is my 5th year teaching property. And as such, I know about all the basic property concepts, but to be able to write on those concepts and study how they apply in different situations in different areas, I mean, it's improved my teaching immensely. Because you know how it is, if you're going to teach something, the level to which you have to know it is far, far, far beyond the level to which you're teaching it. So I'm a big fan of being able to write in the area that I'm teaching. But I think almost more importantly, it helps me convey a certain passion to my students who really kind of take that on, right? When we read about these cases in the book that are good cases, right, and show us these concepts, it's not the same as talking about something that's happening in Detroit, something that's happening across the street in the Hill, right? And so to be able to talk about these issues and convey these issues to my students and discuss different solutions and the pros and cons of those solutions, it just makes all the difference.
I'm going to say something that is going to be a bit controversial, but I think it's important for a teacher to publish in that area because it gives us, it legitimizes us.
Yeah, I think I needed that legitimacy. I mean, coming out of academic excellence, which is a different topic for a different day. But certainly that has helped me. I mean, that made me the teacher I am. But I would agree. Different professors may think differently, and they are still excellent professors. Absolutely. But for me, this is how I am comfortable teaching property, in that I study property. Yeah, like maybe I wouldn't be comfortable, teaching tax or teaching things that I don't study.
And you don't research and write about. And I know, okay, maybe it will come up because otherwise I will have to divagate again and ask you something else. But let's see, maybe it's going to come up in another answer. The eighth question is, what are you working on right now?
Yeah, that's a great question, Donna. Need to get to that. So I'm writing a piece that isn't fully developed yet. The thesis isn't fully developed, but it talks about our concept of property rights here in the United States, which is described as a bundle of sticks, right? There's all these rights associated with any piece of property that can just be doled out, sold, monetized to different parties, right? And continuing on in my theme of individual rights versus community rights, I'm writing about, or researching now, I suppose, ways that the community is considered within those sticks, if they are considered in those sticks in any way, or if it's possible just to create a stick to give to the community. So while my last piece was about a really specific situation that occurred in a specific place, perhaps, this is more broad. Where in our conception of property rights do we even consider how we live together as a community?
And this is my segue into what I wanted to ask you. I know that you're looking at property from a comparative angle as well. So how would that fit in this analysis?
Yeah, it's interesting. And eventually I do want to write a comparative piece on that. I have decided they are two different pieces because you know how it is when you start a paper, it ends up being 2 or 3 papers, and that's where I am. So now I'm writing about the American conception. We see in civil law society that the bundle of sticks isn't a thing there, right? It's more a rights-based property where you really just have the property, you have all the rights to the property, but the government has rights to that as well. I haven't really developed a comparison yet, but I would like to. What I would like to look into is which is better for the community, for society, especially in urban areas, right? Because those are the places we really live together. Although certainly in all areas we're sharing resources.
I'm sorry to say, as someone who teaches climate change law, we are all together.
We are all together on this planet. But yeah, so oftentimes we think of European nations, continental nations, especially, as being more societally focused than American nations, or America as a nation, perhaps the United States. So, I mean, the question is, does it relate to our conception of what it means to own property or not?
That is going to be a very interesting piece from my perspective, or at least right now, is viewing property as if we are all, you are an individual, I am another individual, and we don't interact with each other. So I applaud you for trying to see how this works in our legal system and for adding a comparative angle. Thank you.
Thank you, Donna.
So moving along, what would you like to work on next after this?
After that piece, well, I really want to look at finance in development, right? So sort of municipal finance, but specifically in development, especially, or not especially, but exclusively development that's contracted to private entities and the duties owed by those entities to shareholders and investors as opposed to the community. So as you can see, I'm really just kind of looking at different ways a community is affected. And, you know, while like looking at one specific instance and thinking about an easement to kind of ameliorate issues and looking at it broader from a theoretical standpoint, like it always comes down to money, Donna. It's always about the money. And I mean, we're stuck with these private public functions now. We don't see municipalities funding development.
For lack of money.
Right. But I think it's important to think about who these entities owe a duty to. And it's not the community, right? So how is a community protected in that way? How do we protect the community interest when we're thinking about things like building housing and how much affordable housing is required and whether or not we're allowing you know, various businesses in that development and what the community needs and what the community doesn't need, what's going to come in and push the current residents out. So yeah, like I said, we can look at this from a theoretical standpoint. We can look at the property interest, but it's always about the money. So I'd like to look at that next.
I foresee an amazing scholastic future based on what you're saying. And I wish you good luck.
Thank you, Donna.
Remarkable because I think an element that's lacking in our legal system is the duty towards the community. And no one seems, and because we have this lack of duty towards the community, we see the disaster. We are not making any progress again with climate change law, mitigation, adaptation, and especially prevention. So this idea of duty towards the community is wonderful.
Yeah, it would be nice to see that rolled into our jurisprudence somehow.
Thank you for being so enlightened and helping us.
Oh gosh, Donna, thank you. You give me too much credit, but I appreciate it.
It's based on what I hear and what we are all hearing. So moving along, what would you like? And I'm sorry to say this is our last question. What would you like to share with your students and with everyone else?
Yeah.
As a final thought.
Listen, I tell my students this all the time. The first thing I tell them on the first day, they need to remember two things about property. One, it's about people. And two, it doesn't have to be this way, right? So I really want my students and anyone else who's interested, but mostly my students, to think about how we can use property to better serve people and what that means for our law as it exists now, and perhaps we need to change.
I'm so grateful. I'm getting ready to applaud you. This is marvelous. Property means people. Oh, please go back to your office and start writing more. Thank you so much for being with us here, and good luck with your scholarship.
Thank you.
And we are looking forward to the next installment with our Duquesne Kline Law Library Legal Talk series. Thank you, Professor Herman.
Thanks.